this is an extremely serious error. The tribunal judges what is substantial without any qualification. When does a group of individuals become a community? Would 50 remaining Jarawa tribals qualify as a community or as a group of individuals when their forests are cut down by loggers? Does the individual not deserve protection, or does he have to wait until everyone suffers as much as him? Leaving the judging of the issue to the tribunal to decide whether the group is large enough or the issue is grave enough is ridiculous. Let us suppose I live in a lane of 6 houses, which has 3 peepal trees, and one company comes and cuts them down. This would seem so small to the tribunal, but it is life and death to that lane. Also, much of the pollution is non-point and has so many sources. So these words, substantial, grave, broadly measurable, should be removed. What should the bill add? All issues rising out of non-implementation or compliance of approval conditions should be a subject of the bill. This is one of the main grievances, as you have with all the mining cases that you have taken action on. They take the approvals for a small patch of land and destroy an entire district, as in Karnataka, Andhra, Rajasthan. You have no compliance mechanisms. Why not make this bill one of your instruments? Why is the bill in clause 15 restricting itself to just providing compensation and perhaps restitution of property? Does this make sense? After the companies have finished mining, the tribals will get some money from them and black empty holes in the ground laid waste as restitution. The bill has cut off prospective activity, which includes environmental damage. An amendment is needed here to include prospective damage rather than simply retrospective jurisdiction. Has the ministry not heard of the word precautionary principle? Obviously it has, because that is one of the amendments that it has brought in, and that's well done. But prevention of pollution is the most important way to protect the country. The ministry has protected itself by refusing to give the tribunal teeth to challenge its decisions. While I'm fairly sure that there would be very little need to challenge Jairam's decisions, we have had secretaries like Ghosh and ministers like Balu and Raja and Meena and Kamalnath who march to different drummers. Therefore, the bill should be amended to give it powers to review a statutory authority's exercise of judgment. The courts are subject to review of their decisions. Why not a ministry or an expert appraisal committee? Bring in amendment for review of abuse. I am going to take 10 minutes more. For review of abuse of authority or failure of application of mine. Then you will see that government clearances will survive vested interests. According to clause 15, the tribunal can give compensation to the victim, but it cannot quash the approval granted. Is that right? What does this mean? So I can keep giving money in the air notionally to the forest dweller, but I cannot stop the mining license? In which case, what is the point of the bill? On one hand, the bill can give compensation to individuals. On the other hand, it prevents them from approaching the tribunal before the license is made pakka. So basically, this bill is neither fish nor fowl and will help polluters carry on as business while giving money to their victims. Either the drafting is poor, or this is a deliberate attempt to make something useless again. Has the bill got any real power?
कृपया समाप्त करें, आपका समय खत्म हो गया.
जी? I'm afraid you'll have to give me some time, sir, because this is really important.
ठीक है.
मैं 10 मिनट लूंगी.
10 मिनट नहीं.
मैं माफी चाहती हूँ कि मैं एक्सीड कर रही हूँ, लेकिन ये बहुत इम्पोर्टेंट है.
सिर्फ 5 मिनट. 5 मिनट में खत्म. ठीक है. उसमें कोई खराब थोड़ी होगा.
अच्छा. Has the bill got any real power? The proposed enactment does not have the power to stall any project that caused damage to the environment. It can act only when the damage is done by dealing with the origin of pollution. It also fails to hold delinquent polluting companies criminally liable for their acts of omission and commission, such as Bhopal's industrial disaster or any, God forbid, nuclear accident. One of the significant amendments proposed in the new draft is that decisions of the tribunal can be challenged in the Supreme Court. The earlier draft said that the tribunal's decisions would be final and binding. The amendments still do not address some core concerns. For instance, the bill is vague about tribunal's mandate and states it will deal, as I said before, with substantial questions. And that means it will only look at single point sources of pollution and not cases where there are multiple points. Should this tribunal not have the power to act for the protection and cancel environmental clearances if necessary, provide incentives to individuals who work as eyes and ears to nature and wildlife? Why should it penalize alert NGOs and civil society for raising their voice? Should it not have the power to issue contempt of court notices to polluting companies? Clause 18E is another bizarre clause which says that among the people who can file for relief, compensation or settlement is any representative body, organization functioning in the field of environment. This is problematic. There is no reason why only an environmental organization can file appeals before the tribunal. Why not human rights organizations, public health organizations, labor groups, plaintiffs? Why should the permission of the tribunal be needed before applications are filed before it? This portion of the bill should simply be deleted before it heads inevitably towards a constitutional challenge in the Supreme Court. All Indians are affected by a pollution problem and when their rights are taken away. For instance, in Kutch, where companies have come and drilled deep wells in the ground, robbed hundreds of villages of their groundwater, is that not a human rights problem as much as an environment? If an authority takes away a forest and substitutes it with an iron ore company in Odisha, is that not a human rights problem? The rights of social organizations to approach the tribunal should be expanded because at the moment the provisions are draconian. In 18E, a number of institutions need not be representative or even working in the field of environment and yet be concerned about environment and loss. This line has to be amended if justice is to be served. I want 3 minutes more. When can we approach the tribunal? Limiting the period of accountability. Section 14(3) of Chapter 3 in the bill deal with the tribunal's jurisdiction. It reads, no application for adjudication of dispute under the section shall be entertained by the tribunal unless it is made within a period of 6 months on the date to which the cause of action for such dispute rose. It is not clear why there should be such a restriction. Disputes can rise at any time. It's silly to expect that only those that rise in the first 6 months should be entertained by the tribunal. The bill is also silent on where it should take disputes that rise beyond this window time. If I miss the 6-month window, where should I go? Similarly, 15(3) says, no application of grant of any compensation or relief or restitution of property or environment under this section shall be entertained by the tribunal unless it is made within a period of 5 years from the date on which the cause of such compensation or relief first arose. The adverse effects of so many public health hazards, silicosis, asbestosis, radiation exposure, chemical exposure, for instance, take much more than 5 years to manifest themselves. Therefore, this fixed bonding or boundary of 5 years should be removed, or the bill should specify who will be liable for adverse effects discovered beyond this time limit. Where should the people of Bhopal go? Exactly. In Section 16, that deals with the appellate jurisdiction of the tribunal in the manner of any person aggrieved by orders or decisions of the Tribunal or National Biodiversity Authority or State Biodiversity Board under stipulated condition of the NTG bill. The person aggrieved can file an appeal between a period of 30 days from the date, which I think you've amended now to 60 days.
Please conclude.
I'm 1 page more, sir. 1 minute more. On which the order of the decision.
Yes, only.
This period of filing, I beg leave for another minute. The period of filing the appeal is too short and should be extended to 60 days, as often individuals are prevented by unavoidable situations from filing appeals within 30 days. So therefore, Clause 16 needs to be amended to remove or liberalize time frames. The last thing is an implicit threat to petitioners. Section 22 of 2 of the bill reads, where the tribunal holds that a claim is not maintainable or false and vexatious, the tribunal may make an order to award costs, including lost benefits due to any interim injunction. This provision, according to all the NGOs who have studied it, is very discouraging. In general, the courts always have a general right to impose costs of trials and other costs upon petitioners or the accused. This is taken for granted. There is no need to include this explicitly in section 22(2) because it will deter people who are poor, concerned citizens from bringing in environmental issues before the tribunal, fearing the imposition of heavy costs in case their claim is disallowed. In any event, the correct way to tackle this is for the tribunal to decide whether prima facie the claim made by the petitioner is allowed before it and whether any defendants have a fair amount of explaining to do. If this is done right in the beginning, there is no need for imposing any costs of trial or punitive costs at the end of the trial.
Please.
I would thank you for giving me this opportunity. I would like Mr. Jairam to bring in these amendments to make you and I on the same side. Long after we are gone, this tribunal might hold up to protect India and to take some of the pressure off to make environmental ministers honest and efficient. Otherwise, there is no other protection you will have except for this bill. I would urge you to accept these amendments, which are in the interests of India.